Most people believe that property in India can be transferred only through sale deed, gift deed, or will. But the legal reality is quite different. Very few people know that Indian law recognizes several other powerful legal methods through which property rights can transfer, sometimes even without executing a traditional sale deed. These methods arise from important laws such as Transfer of Property Act, 1882, Indian Succession Act, 1925, Hindu Succession Act, 1956, Indian Trusts Act, 1882. In this video, we will understand 6 important but lesser-known legal methods of property transfer in India, namely 1. Partition, 2. Exchange, 3. Lease, 4. Transfer through court decree, 5. Succession or inheritance, 6. Transfer through trust. If you are a property owner, legal heir, investor, or planning estate management, this information is legally very important. So stay with me till the end. Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. 1. Partition, division of joint property. The first method is partition. Partition is very common in joint family property or co-ownership property. When 2 or more persons jointly own property, they may decide to divide the property so that each person receives a specific and defined share. Legal position. Partition commonly arises in Hindu joint family property under Mitakshara law, while the rights of heirs are governed by the Hindu Succession Act, 1956. A partition can take place through family arrangement, partition deed, court decree. A partition deed may be oral in certain family arrangements, written, registered. However, if the partition is reduced to writing and creates rights in immovable property, it must be registered under the Registration Act, 1908. Example: suppose 3 brothers inherit ancestral agricultural land from their father. Instead of continuing joint ownership, they decide to divide the land. Each brother receives 1/3 share of the property. After the partition, each brother becomes the independent legal owner of his respective share. Advantage: partition helps in clear ownership of property, avoiding future family disputes, simplifying property management. 2. Exchange of property. The second method is exchange of property. Exchange is governed by Section 118 of the Transfer of Property Act, 1882. In an exchange transaction, 2 persons mutually transfer ownership of their properties to each other. Key features: property is exchanged for another property. Money may or may not be involved. Registration is usually required for immovable property. Example: imagine 2 farmers living in neighboring villages. One farmer owns land far from his house, while the other farmer owns land near his residence. They mutually agree to exchange their lands for convenience. Both parties execute an exchange deed, and ownership of the properties legally transfers. Practical importance: exchange transactions are often used when convenience and location are more important than monetary consideration. 3. Lease, transfer of right to use property. The third method is lease. A lease is different from a sale because ownership of the property does not transfer. Instead, the right to use and enjoy the property for a specific period is transferred to another person. Legal provision. Lease is defined under Section 105 of the Transfer of Property Act, 1882. According to this provision, a lease means transfer of the right to enjoy immovable property for a certain period in consideration of rent or premium. Key elements of lease. A lease generally involves 4 essential elements. Lessor, the owner of the property. Lessee, the person who receives the right to use the property. Rent or premium consideration paid for using the property. Specified time period, duration of the lease. Example: suppose a landowner owns a piece of land but is unable to use it himself. He allows another person to use the land for a fixed period of time in return for an agreed annual rent. During this period, the person has the right to use the land. The ownership of the land still remains with the original owner. After the lease period expires, the right of possession ordinarily reverts to the lessor unless the lease is renewed or extended according to law. Legal requirement. If a lease of immovable property is for a period exceeding 1 year, it must be registered under the Registration Act, 1908. Important note: a lease does not transfer ownership of property. It only transfers the right to possess, use, and enjoy the property for a limited period of time. 4. Transfer through court decree. Sometimes property transfers not by agreement but by order of a court. When courts decide property disputes, the judgment or decree may result in a change of ownership or legal rights. Common situations. Property transfers may occur through court decrees in cases such as partition suits, specific performance of contract, inheritance disputes, divorce property settlements. Example: suppose a person agrees to sell property but later refuses to execute the sale deed. The buyer may file a suit for specific performance. If the court passes a decree in favor of the buyer, the court may direct execution of the sale deed, and in certain situations the court decree itself becomes a legally enforceable transfer of rights. Importance: a court decree has full legal authority and must be respected like any other legally recognized transfer. 5. A succession or inheritance. The fifth and one of the most important methods is succession. Succession means transfer of property after the death of the owner. This transfer happens automatically according to law. 2 types of succession. 1. Testamentary succession, when the deceased has left a will. 2. Intestate succession, when the person dies without making a will. Intestate succession is governed by laws such as Hindu Succession Act, 1956. Indian Succession Act, 1925. Example: if a person dies without leaving a will, his property automatically passes to legal heirs such as spouse, children, or parents according to succession laws. Practical importance. Succession laws ensure that property does not remain ownerless and passes legally to rightful heirs. 6. Transfer of property to a trust. The sixth method is transfer of property to a trust. In this method, a person transfers his property to a trust through its trustees, who hold and manage the property for the benefit of the beneficiaries according to the objects of the trust. Trusts in India are governed by the Indian Trusts Act, 1882. Example: a person may create a charitable trust for purposes such as education, religious activities, public welfare. He transfers his property to the trustees of the trust, so that the income generated from the property can be used for charitable or public purposes. Important feature: once property is transferred to the trustee for the purposes of the trust, the trustee becomes responsible for managing the property. The property must be used for the benefit of the beneficiaries. The trustee must manage the property according to the terms of the trust deed. Legal note: the person who creates the trust is called the settlor, and the person who manages the trust property is called the trustee. The trustee holds the property in a fiduciary capacity for the benefit of the beneficiaries. Summary. Let us quickly summarize. Apart from the 6 commonly known methods of property transfer, namely sale deed, gift deed, will, power of attorney, relinquishment deed, family settlement, Indian law also recognizes 6 additional legal modes: 1. Partition, 2. Exchange, 3. Lease, 4. Court decree, 5. Succession or inheritance, 6. Trust transfer. Understanding these legal methods is extremely important for property owners, legal heirs, and investors. Practical legal advice. Before transferring property, always consider legal validity. Stamp duty implications. Tax consequences. Possibility of future disputes. Most importantly, proper legal advice at the right time can prevent long and expensive litigation in the future. Legal disclaimer. This video is provided only for legal information and educational purposes and should not be considered as legal advice. For specific cases or legal disputes, please consult a qualified legal professional. Thank you for watching. If you found this video helpful, please like, subscribe, and press the bell icon for more legal insights. You may also join this channel by clicking the join button below this video and support my efforts in spreading legal awareness among citizens. Jai Hind! Jai Bharat!